Hi, I'm Sandra Burris with Keller Williams Realty. Today we're going to talk about marriage, divorce, and real estate. Stay tuned. Yesterday I attended the most incredible class put on by Republic Title. The class was Death, Divorce, and Real Estate. Today we're going to talk about the divorce part of it. In our next video we'll talk about the death part of it. First of all, let's go over a little bit about how Texas views marriage. In Texas, you're married until you're not married, which means there is no legal separation in Texas, and even if you get a legal separation in another state, it doesn't apply here. Really important to know. Also, common law marriage is a thing. I used to think that you had to have been living with somebody for 5 to 7 years for it to be considered common law, but the reality is there is no time frame. It can be as short as 6 months. It depends specifically on how those two people live together, and that can be determined by a judge and a jury. Common law marriage, just like any other marriage, requires a judicial decree to dissolve the marriage. The other thing is, in Texas, all marriages are legal, and any marriage from any other state is viewed as a legal marriage in Texas. Okay, so what does all this mean pertaining to real estate? In Texas, we have homestead rights. So if you are purchasing real estate and you've got a lender, both parties will need to be on the deed, whether they're on the mortgage or not. So there's some instances where a couple will be purchasing a home and one has great credit and one doesn't have great credit. The mortgage will be under the one that has better credit. But even still, when the home is purchased, both parties have to sign on the deed paperwork. Now, when you're selling a home, both parties are required to sign the deed to convey a homesteaded property. Now, what does that really mean? So, for instance, when a couple marries, they may each own independent property. Now, when one of them moves in with the other, at that point, they can claim that property as their homestead. Any other property does not get to keep the homestead exemption. Now, there is no exception to this. This is by state of Texas Constitution. It's up to you as a homeowner to remove any exemption that you are not currently using on your property. The county is able to come back to you for past due taxes if you do not remove an exemption from your property. Say you get in May your tax statement from the county and you look at it and you see that there is a homestead exemption on the property that you're currently using it as an investment property. It is up to you as the owner of that property to remove that exemption, or else you can be liable for back taxes. That is something I did not know, and I think is super important for us to understand as property owners here in the state of Texas. One thing that happens during a divorce is often one party is awarded the homestead of the home that they shared. During the time of the divorce papers being drafted by the attorney, they can also draft a new deed. Now, it is the responsibility of the owner to file that new deed with the county, and is really important because if it is not filed with the county, the other property owner's name stays on that property. And there can be other ramifications that may make it difficult when it's time for you to sell that property. If you are divorcing, go ahead and have that deed drafted and file that with the county as soon as possible. Now, I know divorce is not the most fun thing to talk about, but I found it very interesting, and I hope you did too, whether it's for you or someone you know that may be going through a divorce. I thought it was great information. If you'd like some additional information or would like to chat with me about it, definitely reach out. Thank you so much and have a great day.